There might be Judge Ansel physically here today.
Huh?
He might be physically here. I saw him in the hallway a few minutes ago.
Who?
There, Bargosian.
Oh, okay. You want to see if you can drag him over here, and then we can get Mr. Dillard on.
Hey, excuse me,
Yes,
Judge.
sir.
Would I get to speak with my attorney to figure out like what's going on or anything?
Yeah, so it's a probation violation, and it looks like Miss Underwood, was appointed, but Miss Underwood had a loss in her family, so she's not here this week. So Mr. Degger Margosian will be able to Zoom with you real quick, okay?
All right.
Okay. All right. Hey, Mr. Degger Margosian. I have Mr. Dillard from MDOC, and I know you're filling in. Mr. Dillard wondered if he could talk to you for 2 seconds.
Sure.
Or do you want to just give him an update on the record? So let me call the case. So this is in the matter of the people of the state of Michigan versus William Jarrett Dillard, 23-21360-FC. Mr. Dillard is currently in the Michigan Department of Corrections. This is a violation of probation, and Mr. Dillard was appointed to Miss Underwood. So I have, this is a violation going all the way back to July. And the violation is that he consumed alcohol on or about July 21 and operated a motor vehicle and without a license. So Mr. Dillard, just real quick, what is your out date or your earliest parole date from MDOC?
I don't have one. They put everything in adjournment until I was done with all of this. So I don't have no date or anything.
Okay, and what is the offense you're currently serving on?
Second-degree arson.
Okay, all right, and this is an unarmed robbery. All right, so Mr. Degger Margosian, update wise, this is just a pretrial. And so how do you want to proceed today?
And Judge, this is for a VOP?
Yes.
Correct, okay. So, Your Honor, that's the court's where I'm filling in for Miss Underwood, who is obviously more familiar with this matter and the proceedings. However, in reviewing this file and what I will suggest to the court, and I'm happy to talk with Mr. Dillard as well, but because he's in DOC and because of, I guess, the nature and the relative minor violation versus what, could be a more serious violation, frankly, I would ask the court to possibly dismiss the violation of probation if Ms. Teskey felt that was appropriate as well, because Mr. Dillard, sort of has bigger things on his plate. But again, I'm happy to talk with him as well.
Mr. Hartung, you are the prosecutor that was on Mr. Dillard's file. He was returned to MDOC on a parole violation. And then this is, and I don't know if you remember, this is the, he was charged with armed robbery and assault with intent to rob while armed. And then he ended up pleading to an unarmed robbery. This violation is for consumption of alcohol and operating a motor vehicle without a license. And I didn't know if you wanted to weigh in on Mr. Degger Margosian's request.
Sarah, is this yours?
This is Miss Walsh, but
Okay.
I'm covering for her.
So who has the jurisdiction on the charges that he's facing right now? Are they Adrian?
Mr. Dillard, you were the case that you're currently incarcerated on. That was a Lenawee County case, was it not?
Which one? Like that I'm on parole for?
The one you're doing time on right now.
Yes, everything, yeah.
Yeah.
Okay, so what is his current sentence?
I just
So right
got
now, I
90.
think,
I
Go
got
ahead.
93 days for the OUI and they dismissed my driving without license. I
Okay,
got that on the 17th.
all right, and where are you at right now, sir?
I'm at RGC quarantine.
Okay, and when are you don't have an out date yet?
No, because they put everything in adjournment until I got all of this done.
he's serving right now on his arson charge that was a 2013 file. It's an active sentence, and it looks like he got 3 to 20 back in. It says it's active, so that's the one you got flopped
Yeah.
on. Okay, so he's
Yeah.
actually in serving time now on a parole violation for second-degree arson.
And was that parole violation for the unarmed robbery conviction?
No, I'm here for the OUIs.
Oh.
The OUIs sent me back and driving with no license.
I don't have a problem with whatever Miss Walsh is. Miss Walsh the parole officer on this, or is it David?
She's
It's
my
Dave.
probation officer.
So Ms. Walsh is the probation officer on the file that I have in front of me today, which is a probation violation. And Dave Face is the parole officer on the arson file.
I don't have any objection to it being dismissed. But again, I think
Judge, if you want, I mean, we could, to keep the record clean, we could just do an immediate sentencing on the violation as well.
Okay, and what would you recommend?
Well, he was returned to prison, so I would just recommend credit for time served.
All right,
That would just kind of keep the record a little bit cleaner with the violation.
so Mr. Dillard, luckily for you, I have Mr. Hartung here, and I have Mr. Degemer goes in and Ms. Teskey. And Mr. Hartung, would you have any objection to that?
that's fine.
So Mr. Dillard, if you wanted to plead to the violation of probation today, I would give you credit for time served.
Yes,
Today.
ma'am.
Is
Yes,
that what you want to do?
yes.
Mr. Degemer goes in. Do you have any objection to that?
No, thank you.
All right, so Mr. Dillard, do you want to raise your right hand for me? Do you solemnly swear, it's okay, or affirm that, hold on. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Now, Mr. Dillard, I know Mr. Degemer is here today, and we had a lot of conversations on the record. Do you feel you need to speak with him privately?
No, ma'am.
Okay, and so far, have you been satisfied though with Mr. Degemer and Ms. Underwood as your attorneys on these?
Yes.
Now, understand that you're currently on probation for unarmed robbery, which carries a maximum penalty of, I don't even remember now, is it 10 years?
15.
Oh, yeah, 15 years, but there's been a discussion on the record that your sentence would be credit for time served. So, you know, you understand that's what you're looking at.
Yes, and what would what would that be basically though? Like no more.
Since I arraigned you, I guess, on, I arraigned you back on, let me see here, August 4, so I give you credit back to August 4.
Okay.
Okay,
Your Honor, you would be continuing probation as well, correct?
yeah,
All right.
Okay.
Yes.
okay. All right, now, do you understand that you have a right to contest the violation of probation charge and to have a trial on it?
Yes.
Do you understand that throughout this trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at the trial. Do you understand all of that?
Yes.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yeah.
On the other hand, do you understand you have a right to testify at your trial if you want to testify?
Yes.
How do you plead to the charge that you violated the terms of your probation by consuming alcohol and operating a motor vehicle without a license. Guilty or not guilty?
Guilty.
Do you understand by pleading guilty, you'll be giving up your right to a trial as I've already explained to you?
Yes.
Now, obviously, we had a discussion about a sentence, but has anything else been promised to you to get you to plead guilty?
No.
Has anyone threatened you in any way to get you to plead guilty?
No.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty?
Yes.
So, Mr. Dillard, one of the terms of your probation is that you weren't to consume alcohol. Is that correct?
Yes.
And another term would be that you are not to violate any state laws. Is that correct?
Yes.
Now, on July 21 of 2025, did you consume alcohol?
Yes.
And did you drive a motor vehicle?
Yes.
And you didn't have a valid driver's license. Is that correct?
No, ma'am.
Okay, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. So, Mr. Dillard, you have a right to have a pre-sentence or a probation violation report done. Do you want to waive that and be sentenced today?
Yes.
Okay, Mr. Decorum, is there anything you'd like to say on behalf of Mr. Dillard?
No, thank you.
All right, Mr. Hartung, anything?
No, Your Honor.
All right, Mr. Dillard, anything you want to say on your own behalf?
No.
All right, so it's sentence of the court that you'll be given credit for time served going back to, I think I said, August 4 of 2025. And I will continue your probation. Obviously, when you get released from MBOC, you need to report to the probation department as well as your parole officer, okay?
All right.
Now, I wish you the best of luck, Mr. Dillard. Thank you.
All right. Thank you.
Thank you.
Hey, could you make sure that I get the paperwork that comes with me sent to here?
Yeah,
how
no,
would I-
we do send it. I don't know where it goes, but we do send it, okay?
All right.
All right, thank you, Mr. Dillard. So we can handle him, or I know I stole you from another court.
This will be quick, if we could just do this.
Sure.
Thank you.
All right. Mr. Villarreal. Okay. Oops, and now I'm pull a chair out for him. Michael. Okay. All right, very good. Let's get him seated. Okay, so this is in the matter of the people of the state of Michigan versus Philippe Villarreal, file number 24-22055FH, of Michael Dagger appearing on behalf of Mr. Villarreal, and I have Isaac Sneed appearing on behalf of the people. This is a date and time set for a pretrial conference. So, Mr. Dagger, how would you like to proceed?
Your Honor, Mr. Villarreal continues to make payments pursuant to the ECU program. It's a high amount, but he continues to pay it down in the required amounts. I'm just asking for an adjournment here for him to continue to make payments.
So you want an adjournment? How far out?
Whatever the court's going to do, I mean, another, 2 months, I think will give him enough time to make another chunk of the payment.
Okay, so why don't we, Mr. Sneed, no, any objection to that?
No, thank you, Your Honor.
All right, why don't we set this out to January 7th at 8:30 in the morning. So pretrial for January 7. Miss Adams, could I get a notice of hearing from Mr. Villarreal?
Yes, Judge.
All right, and so, all right, so Mr. Villarreal, just have a seat there and stay there. We'll get you a notice. You didn't go to Michigan, did you?
I don't know.
I know.
I went to Evanston,
That's what I thought.
Go Green.
All right. And you don't need, you don't need to do the step in order, right?
Okay, thanks.
Yeah, it's like a green in this room,
Yeah.
or Michigan State grads, yeah.
I do have a tiger shirt on.
Okay, as long as you're wearing a tiger shirt.
Because it was.
All right, so. Let's see, Mr. Mont, your client's in jail, so I'm gonna call over there. I got Sam Malaro, so I'm gonna go with Jake Klein, Chad Stewart, Lewis Adams, okay. Thank you, Miss Adams. Hey, this is Judge Anselon. So I am ready for Jake Klein, Lewis Adams, and Chad Stewart.
One ball at the same time?
Sure, if you got windows, I'll take them.
Sounds good. I'll thumbs up.
All right, thank you so much. Bye.
Bye.
Stapler join? Yes. Go, you're welcome.
You can keep it if you need it.
You got one. I just got to put staples in it.
Oh, okay.
I thought I had staples in here. Oh, I do. Okay. All right, so can I ask what your name is?
Michael Newsom.
All right, Mr. Newsom. So you're here just to watch?
I had a show of cause today. Child support,
Where?
child support.
So we do those on Mondays. Do you have your notice of hearing?
I had it, it said Wednesday on the paper, Wednesday at 8:30.
Oh.
I didn't read because I was.
Okay, hold on. What's the other party's name?
Jerry Donald.
Jerry Donald?
Yeah.
So Miss Adams, could you look up Michael Newsom or versus Jerry Donald?
Donald.
Dolly, okay. Okay. In the matter of the people of the state of Michigan versus Angelina Ann Hall, file number 25-22152FH, says the date and time set for a show cause in this matter. Ms. Hall was ordered to appear. She has failed to do so. I'm going to issue a bench warrant for her arrest. I'm going to set bond in the amount of $25,000. Cash. In the matter of the people of the state of Michigan versus Alvin Graves, file number 23-21428FH. Mr. Graves was ordered to appear on a probation violation today. Mr. Graves has failed to appear. I'm going to issue a bench warrant for his arrest. I will set bond in the amount of $25,000 cash. The matter of the people of the state of Michigan versus Cody Kuzino, file number 25-22104FH, 25-22151FH, 25-22198FH. Is the date and time set for show cause in this matter for probation violation. Mr. Kuzno was ordered to appear. He has failed to do so. I'm going to issue a bench warrant for his arrest. And I will set bond in the amount of $25,000 cash on each file.
Judge, I'm not finding anything. Maybe if he wants to check with friend of the court.
So you got a couple options. I don't have you on my docket today,
That's fine.
but what I want you to do is maybe go down to front of the court and right across from the elevator, there's a window.
Yeah.
And ask them.
Okay, thank you, I appreciate it.
No problem. Sorry about that.
Thank you.
Mr. Malaro, I have Ms. Clough.
Okay, in the courtroom or in Zoom?
On Zoom.
All right, because that's what she said she was gonna do last time.
All right, Amy Clough, if you want to go ahead and unmute your device and start your audio, please.
Yep.
All right, this is in the matter of the people of the
Right.
state of Michigan versus Amy Lynn Clough, file number 25-22154FH. Ms. Clough has appeared via Zoom. I do have a letter from Darren Coast, my pretrial services coordinator, stating that she continues to do very well in her participation in the Hillsdale County Family Court. She is engaged in counseling and all of her drug screens have been negative. Amy had a baby boy this past weekend. Congratulations.
Thank
And
you.
both are doing great. She is zooming in for her pretrial. So Ms. Clough, what is the status of the family court in Hillsdale County?
I moved to unsupervised visits next week. I phase up to phase 3 out of 4 phases.
Nice.
The week on the 21st, I think it is, that week I phase up. I have to do 90 days in phase 3 and then 90 days in phase 4. We go back to court December 11th. And kind of see where I'm at that point, but I'm doing very well and I'm almost done with it.
Yeah, I bet.
Oh, excellent. Yes, yes, Ms. Demont. I would say, Mr. Malaro, nice glasses, represents Amy Clough, and I have Isaac Sneed on behalf of the people. So, Mr. Malaro, how would you like to proceed?
Judge, if the court recalls, we had a bench conference a few weeks ago, and Ms. Clough was trying to decide whether to accept the plea offer. Could I have a brief breakout to see if that's what she wants to do?
So I'm going to open up a breakout room. And all right, I'm going to open up the breakout room for you to go ahead and join that breakout room. Ms. Dumont, I have Jake Klein. So in the matter of the people of the state of Michigan versus Jake Klein, file number 25-2240202FH. I have Ketter, let me see, I have, this is a violation and a pretrial. I have Isaac Sneed appearing on behalf of the people and Katerina Dumont appearing on behalf of Mr. Klein. This is a date and time set for a pretrial. In my file, I have an advice of rights form that's been signed by Mr. Klein, as well as a plea agreement form, which states that Mr. Klein will plead guilty to count 1 as charged, which would be retail fraud, first degree. Is that with a second offense then, as a 5-year felony, Mr. Sneed?
I'm bringing up that plea form right now, Judge. If I could just
It
have one
says
second.
no habitual, but I'm assuming it's with the second offense.
Yes, Your Honor.
It is, Ms. Demont?
Yep.
Okay,
With.
so the maximum penalty could be up to 5 years in prison. He does have a habitual offender 4th offense notice, and that would be dismissed at the time of sentencing. I do not see any, let me see here. There's no sentencing agreement, Mr. Mont?
Yes, Your Honor, I had worked with prosecution to get the sentencing agreement off because he was sentenced in the probation violation to the RAP program.
So MDOC has closed the RAP program, and I am devastated because it is one of the best programs we've ever had. So Mr. Moore, they are not accepting new people, is that correct?
Yeah, that's correct. About an hour after his sentence last week, we received an email informing us that. So that's where we're at right now.
And I don't know, I mean, I'm assuming it's due to budget cuts or whatever, but I am devastated because that program was a great program. So that is no longer available to him, Ms. Demont.
Yes, Your Honor. So I would think then we would set sentencing for this and then maybe resentencing on the violation of
At
probation
the same
charge
time.
and see what we can offer him.
All right. All right. So Mr. Klein, do you want to raise your right hand, please? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. Can you state your full name for the record?
Jake Gordon Klein.
All right, so Mr. Klein, you've heard the statement of your attorney, myself, and Mr. Sneed, that is a correct recitation of the plea?
Yes.
All right, and is it your intention today to plead then guilty to count 1, retail fraud, first degree as a second offense, which carries a maximum penalty of up to 5 years in prison?
Yes.
Are you satisfied with your attorney and the advice that she has given you?
Yes, Your Honor.
Do you understand, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
Ms. Demont?
Yes, Your Honor.
And Mr. Klein, is that correct as far as you are aware?
Yes, Your Honor.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Klein?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding, failing to appear for sentencing, violating terms or conditions on bond or the term of any sentencing or plea agreement, or otherwise failing to comply with the order of a court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, Mr. Klein?
No, Your Honor.
All right, Mr. Klein, how do you wish to plead to the charge that on or about August 1 of 2025 in the city of Adrian in the county of Lenawee, that you did commit the offense of retail fraud first degree?
Guilty, Your Honor.
And then you have a prior retail fraud, let me see here, on November 17th of 2022, is that correct?
Yes, Your Honor.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Sneed?
No, Your Honor.
Ms. Demont?
No, Your Honor.
All right. Has your attorney promised you any particular sentence or estimated what your sentence will be, Mr. Klein?
It got taken off the table, so no, not anymore. Your Honor.
Okay, and that was about the RAP program.
Yeah, it was 6 months before that. Then it was supposed to be the RAP program. So I don't even know what's going on anymore. Sorry, Your Honor.
Yeah, so there's no sentencing agreement anymore, and that really is not something that we had control over. You understand that, Mr. Klein?
Yes, Your Honor.
But you still want to enter the plea.
As far as I know, yes, Your Honor, I think so.
Okay, so it's your own choice to plead guilty, right?
Yeah. Yes, Your Honor.
Okay, so Mr. Klein, on August 1 of 2025, were you in the city of Adrian in the county of Lenawee?
Yes, Your Honor.
Okay, so this isn't one I've usually seen before, especially with two guys. So you went to Hobby Lobby, is that correct?
Yes, Your Honor.
And was the store open? It was during hours when it was open to the public?
Yes, Your Honor.
Okay, and you took property from there that had a value more than 200, but less than 1,000. What did you steal from Hobby Lobby?
Shirts to make there's t-shirts and sweatshirts.
Okay, so you stole t-shirts, all right. And when you took those t-shirts, your intent was to deprive Hobby Lobby of the value of those shirts.
Yes, Your Honor.
All right, and then again, you were convicted on November 17 of 2022 for a retail fraud 3rd degree before, is that correct?
Yes, Your Honor.
All right, are you satisfied, Mr. Sneed?
Yes, thank you, Your Honor.
Has the court complied with MCR 6.302 B, C, and D? Mr. Sneed?
Yes, thank you.
Ms. Dumont?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He has competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. And then I'm also going to set his violation of probation file sentencing for resentencing on the same day. So December 5 at 8:15 in the morning. Are you available that day, Ms. Dumont?
Yes, Your Honor.
So Mr. Klein, someone from probation is going to come over and talk to you. Be truthful with them about your background and the events that occurred. They'll prepare a pre-sentence report. Ms. Dumont is excellent about this. She will come to the jail or Zoom with you to review that before the day of sentencing. And we will see you back on December 5 at 8:15. Thank you, Mr. Klein.
Thank you.
Thank you, Ms. Dumont. Good. All right, so I have, let's see, Mr. Malaro, were you taking a plea on Mr. Stewart today or setting a pretrial date?
We're taking a plea on Miss Clough, Judge.
Well, I know, but I didn't know if you were taking a plea on Mr. Stewart. If you were just getting a date, I could do that one real quick.
Oh, let me look. I was out of the office for a while. Possibly might be, but I gotta talk to him about the plea offer.
So I'm gonna skip back to Ms. Clough. All right, so we're back on the record in the matter of the people of the state of Michigan versus Amy Clough. And she is showing us her beautiful baby. So, Mr. Malaro, we had an opportunity to speak with her.
I have, Judge, and I believe we've reached a resolution. Ms. Huff is going to plead guilty to attempted home invasion 3rd degree. There will be a recommended or a sentence agreement of a no initial incarceration. All remaining counts will be dismissed. And I think that's it.
All right. Okay. So you said to an amended information with, what was the charge she was pleading to? Count.
Attempted home invasion 3rd.
Okay, so we're gonna have an added count 3, Mr. Sneed, of attempted home invasion 3rd degree.
It looks like, yes, that would be an added count 3. And we do have that amended information from April, Judge. I don't know if that's in the court file.
Oh, let me look, maybe. In May. In order to adjourn. Release order. I don't think it's not been sent to us, so it's not scanned in or in the files, so that's fine. You can get that over to us. All right.
Will do.
In the max, all right, and that's a 2.5 year, correct, Mr. Steen?
Correct.
All right, so Ms. Clough, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, can you state your full name for the record, please?
Amy Lynn Clough.
All right, so Mr. Clough, Ms. Clough, you've heard the statement of your attorney, the prosecuting attorney, and myself. So is it your intention to plead to an added count 3, attempted home invasion 3rd degree, which carries a maximum penalty of up to 2.5 years in prison, but there is a sentencing agreement that there would be no upfront jail? Is that your intention to plead to guilty to that?
Yes, Your Honor.
All right, are you satisfied with Mr. Malaro as your attorney and the advice that he has given you?
I am.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Malaro?
That is correct, Judge.
Mr. Steen?
Yes, Your Honor.
And as far as you're aware, Ms. Clough?
Yes, Your Honor.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Ma'am, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable had you been convicted at trial? Do you understand that?
I do.
Do you understand that any appeal from this conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea? Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. So basically, Ms. Clough, what that means is if you abscond, if you catch a new offense, if you do anything that violates your probation or family court or anything, you understand you could go to jail and the sentencing agreement would be out the window. Do you understand that?
Yes, Your Honor.
Okay. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that are given to you?
I do not.
All right, so Miss, how do you plead to the charge that on or about November 22nd of 2024 in Rollin Township in the county of Lenawee, that you did commit the offense, that will be listed under count 3, attempted home invasion, 3rd degree. Guilty or not guilty?
Guilty.
Other than what was placed on the record, has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Malaro?
No, you're not aware.
Mr. Steen?
No, Judge, thanks.
Has your attorney promised you any particular sentence, miss, or estimate what your sentence will be outside of the agreement that was placed on the record?
No, Your Honor.
Right, is it your own choice to plead guilty?
Yes.
All right, so Ms. Clough, on November 22nd of 2024, were you in Rowland Township in the county of Lenawee?
Yes, I was.
All right, and did you go to a house located at 1788 North Posey in Rowland Township?
Yes, I did.
Okay, and did you attempt to enter that building?
Yes.
Okay, and was there some destruction of property there that was committed by you?
Yes, in a way, yeah.
Okay, all right, and you had no right to enter that property or commit that destruction, correct?
Correct.
Mr. Steen?
People are satisfied, Judge. Thank you.
All right, has court complied with MCR 6.302 B, C, and D? Mr. Malaro?
I believe the court has, yes.
Mr. Steen?
Yes, thank you.
I accept the plea that has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defendant, the defense attorney, or anyone acting in the interest of either of them other than the Killebrew plea itself. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Malaro, are you available on December 5 at 8:15 in the morning?
I believe I am, Judge.
All right, so Ms. Clough, I'm going to set this for sentencing on December 5 at 8:15 in the morning. You have the right to be present in person, but you can Zoom in if you would like. Would you like to be in person or on Zoom?
Is that a Wednesday by chance?
It is.
Let's do Zoom.
Okay. In light of the fact that you have no initial upfront jail, Zoom is fine. All right.
Okay.
So what I'm going to do is Ms. Teskey or Mr. Moore.
It's me, Judge.
Okay, so Ms. Clough, in a minute here, I'm going to put you in a breakout room with Ms. Teskey, and she's going to get your contact information.
Okay.
She's going to give you instructions. You're going to have to come in. You're going to have to fill out a packet. You're going to have to meet with them. When you do, be truthful about your background, the events that occurred, sign any releases so we can get information from the family court. They'll prepare a pre-sentence report. So make sure, as I said, you be truthful about your background and the events that occurred. Mr. Malaro will get a copy of that to you and review that with you before the day of sentencing. And we will see you back on December 5 at 8:15 in the morning via Zoom. So Ms. Clough, I'm going, yes?
If I may, December 5th is a Friday, just so you know.
I know.
Okay.
And she asked if it was a Wednesday.
Oh, yeah, I'm sorry. It's a Friday, Ms. Clough. Sorry about that.
Okay, I was just asking because I have family treatment court on Wednesdays. If it's a Friday, I can be in person.
You don't need to be in person. You have a baby.
Okay. Okay, cool.
You can
Thank
appear
you.
via Zoom. Yeah.
Thank you.
Okay. Sorry about that. Thank you, Mr. Malaro. Okay, go ahead and join that breakout room. All right, so Chad Stewart, let me grab your file. So in the matter of the people of the state of Michigan versus Chad Stewart, we have two files, 25-22167FH and 25-22168FH. Mr. Hartung, what file are you here on?
Your Honor, I have a case with Mr. Fry with Sierra Gibson.
Okay, let me mark that down. Okay, she is here, so I'll get to that right after this one. All right, so I have a note from Mr. Coast dated October 7 that Mr. Stewart is doing really good with his once a week drug testing. He always misses and he's never negative, but he's in jail. So I know he's not positive now for anything, but so Mr. Malaro represents Mr. Stewart and I have Isaac Sneed appearing on behalf of the people. So how would you like to proceed today, Mr. Malaro? It's my understanding you have a plea.
Well, Judge, we have an offer. I think it's pretty reasonable. So if I could talk to Mr. Stewart, I didn't realize he was in jail. So
yeah. So I'm going to open up a breakout room, Mr. Stewart, and you're going to go ahead and click on Zoom, join Zoom breakout room. And let me get rid of this one. Hold on a second. All right, so Mr. Stewart, I'm going to put you and Mr. Malaro, wherever he is, there he is, into that breakout room. Go ahead and join it.
thank you, Judge.
Okay, Sierra Smith, Sierra. Okay, so Mr. Fry. Sierra Gibson is, which one are you here on?
For Mr. Fry.
Yep, hold on, Miss Gibson, I got him.
Okay, I'm
All
sorry.
right. This is in the matter of the people of the state of Michigan versus Sierra Gibson, file number 25-22225FH. I have Douglas Hartung appearing on behalf of the people, and I have Brian Fry appearing on behalf of Miss Gibson. So Miss Gibson, where you are standing, we can't see you. So I need you to move somewhere where there's light on your face so I can see you. That's all.
Is that better?
That's better. All right. So this is the date and time set for a pretrial. I do have a letter dated October 7 from Darren Coast stating that Ms. Gibson has been doing much better with her testing. She hasn't missed in a couple months and she is staying away from cocaine. Anything else, Mr. Coast?
No, Judge. She's doing a good job now. She hasn't missed some drug screens for the last couple months, so she's doing well.
All right, excellent. So, Mr. Fry, how would you like to proceed today?
Your Honor, yes, me and Mr. Hartung have had some recent discussions on this case. I need a little bit more time to discuss those with my client. So if we could get an adjournment, so we can have those discussions and see how to move forward.
My next available is November 12 at 8:30 in the morning. So Ms. Gibson, I'm going to set this for pretrial on November 12 at 8:30 in the morning. And Mr. Fry, can you do the step in order to adjourn? And Mr. Hartung, can you sign your name with permission?
Your Honor, just is it possible to move that 1 week further? That's during that trial period that we're having in your court.
Okay, November 19 at 8:30 in the morning.
Yeah, that works. I wasn't available on November 12th either, so.
Okay. Is it the same trial?
No.
No, it isn't.
Okay. All right, but okay, so Ms. Gibson, November 19 at 8:30 in the morning, write that down, but Mr. Fry will also mail you a notice of hearing and keep up the good work. Thank you.
Thank you.
Thank you. Thank you, Your Honor.
Thank you.
Thank you, Brian.
So I have somebody in jail Zoom 3. What is your name, please?
Lewis Adams.
All right, let me find you. Your attorney is Brian Fry. So Mr. Fry is here. And so is your mom, right? Your mom is here too, Mr. Adams. She always is. Okay. I have all right. So let me get there. So we have file number 24-21947FH and 24-21948FH, 24-21949FH, 24-22011FH, and 24-22012FH, and 25-22337FH. I have Isaac Sneed appearing on behalf of the people, and I have Brian Fry appearing on behalf of Mr. Adams. I have just received an amended felony information as well as an updated plea agreement. Thank you very much. Mr. Fry, did your client get an advice rights or?
So, Your Honor, could we come back to this if possible? So we've had, I've been speaking with Miss Arnold this morning, and there was an error in the plea agreement that she's going to be fixing, and then she did realize that she hasn't talked to one of the victims on one of the cases, so their prosecutor's office is trying to reach them this morning so we can actually proceed with this.
Okay, so I do have the corrected amended felony information that I just received. And who is the prosecutor on this?
Miss Arnold.
Okay,
Judge,
yeah,
that was an amended plea agreement that I gave you that was sent to me this morning by the prosecutor.
And it had the wrong counts for the plea, so there's going to be another new one.
okay, so Mr. Adams, you just hang tight, all right?
Do we have a breakout room with my attorney?
So just
Is it possible?
of course, hold on. He's kind of a captive audience. He can't go anywhere. So got it. There you go. Join that breakout room. Okay, so I have Sky Sean Tyndall. Is Michael Dagger Margosian. Mr. Tyndall gets here at like 10 to 8 every Wednesday. Or shine. He's always on time. All right, Mr. Tyndall, if you'd like to start your audio and your video, please.
I'm getting ready for work right now, dressed, so I don't want to turn the camera on right now.
Okay.
Yes,
How long
ma'am.
you need to get some clothes
Yes.
on?
Just like 10 minutes.
Oh, okay.
Just brushing my teeth and getting ready for work. That's and putting a shirt on.
Okay. All right. So this is in the matter of the people of the state of Michigan versus Sky Sean Tyndall. We have file number 20-20027 FH 22-20717 FC. I have Michael Dagger Margosian very kindly appearing on behalf of Rhonda Underwood today. And Mr. Tyndall is appearing via Zoom. I do recognize his voice. So Mr. Dagger Margosian, how would you like to proceed today?
Your Honor, Michael Dagger Margosian for Mr. Tyndall. I tried to call him yesterday on a number that I have listed. I wasn't able to make contact with him. I would be asking to talk with him in the break room. However, before that, I mean, I know the court just indicated that he's comes to court and is complying with everything. Based on the violation of probation allegation, looks like the allegation is him really not doing anything. So something is, I need to figure out what's going on here, and the recommendation being a year in jail and a revoked probation.
Hey, Mr. Tyndall.
Yes,
Tell
ma'am.
your roommate they can't be talking.
So sorry.
Okay. Yeah, he always shows up for court.
Yeah. So,
okay. So
Judge,
I guess
a little update. Sorry. He did not report yesterday. I don't know why. But last time we were in court, I had told him there was a bench warrant in district court for his failure to show for a show cause. It's still there, so he doesn't take care of that either.
Man,
and I haven't gotten any payments, so I don't know. I don't know what he's doing, but he's
hold
not
on,
doing
Mr. All right,
anything.
hold on, everybody. Mr. Tyndall, wait a minute. Go ahead. And so he hasn't taken care of the bench warrant in district court yet?
Correct. And he did not report yesterday, and he's not made any payments.
Okay. So I think the last time we were here, I did tell Mr. Tyndall to go take care of that. It's just a show cause bench warrant. And then did you go down there and talk to them, Mr. Tyndall?
Not until tomorrow when I have my check and I can pay it off and not be locked up to be able to work. Yes, ma'am.
Okay. Okay. So I'm going to adjourn this. Mr. Tyndall, when you get your paycheck, you go pay that off and take care of that bench warrant.
I will
But
do
you
it
have to
tomorrow.
report to, yeah, and you want him to report when, Miss Holly, again?
Tuesday. Between 8 and
Mr.
10.
Mr. Tyndall,
will be
what
there.
is your work shift, Mr. Tyndall?
Like today, I don't start until 10. I work in Litchfield. I probably won't end until like 7 or 6:30. But whenever I have court and everything, like they're fine with it. So I would be
All
there for
right,
probation.
so next Tuesday, Mr. Tyndall, be here when the building opens and report to Miss Holly, all right?
Yes, ma'am.
If you don't, I'm gonna issue a bench warrant.
No, I promise I will be there. I promise I will be there.
Okay, so I'm gonna set this out to, and I know you're working, so you need to be paying some money on this.
Yes,
I'm
ma'am.
gonna set this out to October 22nd, Mr. Tyndall, for you to take care of that district court stuff and to report to Miss Holly. So October 22nd at 8:30 in the morning, all right?
Thank you so much.
All right, thank you. All right, thank you, Mr. Dagmar. Was that all right
That's
with
all
you,
I
Mr.? Yeah, thank you. Okay, that's all you had, Miss Holly?
Yes. Yes.
Okay. All right, so we are back with Mr. Stewart, Mr. Malaro. How do you want to proceed?
Judge, I'm going to ask for a brief adjournment. The basis is this: the plea offer involves Mr. Stewart doing recovery court. And he informs me he may have done recovery court in the past. I don't know if he's eligible again. I have to find out. So that's the
Ms.
basis. of my
Teskey, didn't we
request.
just screen him? Sarah Teskey? Tom Moore? Brian Fry?
Did we just screen
Sarah's-
who?
Sarah Teskey?
Can you tell me the name?
Chad Stewart? I thought we just rescreened him.
Well, if he's eligible, Judge, then I think we can do the plea.
Well, I don't know. I thought we screened him already.
I will
Just
tell
recent.
you just a second here.
So is Miss Teskey not doing recovery court any longer?
No, I'm here.
Oh,
So Sarah Teskey, did we just recently rescreen Chad Stewart?
Not that I know of, Your Honor.
Okay, all right, I got him mixed up with somebody else. So he would have to be screened. So are you submitting a request for him to be screened for recovery court?
if he's eligible, yes, we would do that, Judge.
Ms. Teskey, anything that would indicate he's not eligible to be screened?
We can screen him. He is a past graduate of drug court,
Right.
so I'm not really sure. But we can screen him if there's a
Okay.
referral made.
We'll make a referral.
All right, I will set this out to November 5 at 8:30 in the morning, and you need to get that request done like right away, Mr. Malaro.
Absolutely.
All right, and you'll do this in order to adjourn, and Mr. Sneed, can he sign your name with permission?
Yes, thank you.
All right, so Mr. Stewart, we'll see you back on this November, what did I say? Just November 5.
Thank you.
And Mr. Stewart, when you get out, if it's today or tomorrow, you got to come see me next week, okay?
Yeah, I will.
All right.
What's
Okay.
he in for?
It's
Failure.
something downstairs, Judge. I expect he'll be released today or tomorrow.
Okay,
It's not a new charge or anything.
okay, all right, so we'll see you back then. So Mr. Stewart, you will need to, Mr. Coast, continue to report to Mr. Coast and do what you're supposed to do, all right?
Yep, absolutely.
All right, thank you.
Thank you,
Thank you.
Judge.
Okay, so Alyssa Smith is Mr. Malaro. Ms. Smith, you could unmute your device and start your audio, please.
Yes. Can you hear me?
All right. Yep. Great. All right. This is in the matter of the people of the state of Michigan versus Alyssa Marie Smith, file number 25-22390 FH. This is the date and time set for a pretrial conference in this matter. Mr. Malaro represents Ms. Smith, and I have Isaac Sneed appearing on behalf of the people. So, Mr. Malaro, how do you wish to proceed today?
Judge, I have a plea offer that I recently got from Mr. Bayonetto. If I could review it with Ms. Smith, we may be able to get this resolved today.
All right, so I'm gonna close these breakout rooms. Just a minute to close. Just a second. So you're going to get a request, Ms. Smith, to join a breakout room with Mr. Malaro.
All right.
All right. All right, so Mr. Fry, okay. We're still waiting on that one. Mr. Dagger Margosian. I don't know why you're here. No, not you. You. It's at 10 o'clock. Okay.
And then, well, Judge, I also have, at least on Ron's docket, it was the BOP arraignments for Alvin Graves, Angelina Hall, Cody Kuzma.
Oh, none of them appeared. I issued veterans.
This is veterans on those. Wait, but on Angelina Hall.
Who?
For Angelina Hall, I called the jail yesterday. They said she's in rehab.
No, so we're here on the violation. She left of the rehab.
I know, but then yesterday they said that she was, okay.
She's on, we went through this morning. Doug had explained this to me.
Okay.
So she's an H-99 on the jail list, which means she's in custody, but at another facility.
Okay.
So she was sent to rehab, but then she absconded from it.
Oh, I see. Okay. So that's why the jail sees it
Yeah.
as, okay.
So yeah, I issued a bench warrant on each of them for failure to appear and $25,000 cash on each file. Yep. You want back in the jury room while you're waiting or do work or anything?
I'm just gonna be on here. It's okay.
Okay. All right. So we're waiting on the prosecutor. Yes. All right, I'm going to step off the bench for a minute. Ms. Spade, you as well. Thank you, Judge. Yes.
Hi, John.
Sam. Hey.
There are cards circulating for Rhonda?
Yep. Or no, I'm not sure.
Our office cards circulating for Rhonda?
Can you hear me? No.
Please rise for the court's now in session. May be seated.
All right, so we're back. Mr. Adams, just bear with us. But we are here on Ms. Smith, Mr. Malaro. So you've had ample time to speak with her.
Yes, Your Honor, and I believe we have a plea agreement put on the record.
All right. Okay, so who would like to place the plea agreement on the record?
I would, Your Honor. So, Your Honor, pursuant to a plea offer from Mr. Bayonetto, Ms. Smith will be pleading guilty to an added count 2, use of cocaine. There's a recommended sentence of being sentenced under 7411 if eligible. Count 1 would be dismissed in any habitual offender notice. Ms. Smith is currently at the Bear River facility engaging in rehabilitation. So I believe that would be the plea agreement, Your Honor.
All right, would you concur, Mr. Steen?
Yes, that's accurate, Judge. Thanks.
All right, there's no sentencing agreement, Mr. Milaro, just,
Correct.
okay. All right. So Ms. Smith, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Good. Will you state your full name for the record for me, please?
Elissa Marie Smith.
Okay, you can put your hand down. All right, so Ms. Smith, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to an added count 2 use of cocaine that carries a 1-year max on that, Mr. Milaro?
Yes, I believe so.
So the maximum penalty for that, if you pled guilty or were found guilty, could be up to 1 year in jail. Do you understand that?
Yes, Your Honor.
Right. And are you satisfied with Mr. Milaro as your attorney and the advice that he has given you?
Yes, Your Honor.
Neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, other than the agreement, Mr. Milaro?
That is correct, Judge.
Is that correct, Mr. Sneed?
Yes, Your Honor.
And Ms. Smith, as far as you're aware, is that correct?
Yes, Your Honor.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Ms. Smith?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea?
Yes.
Misconduct is defined to include, but not limited to absconding or failing to appear for sentencing, violating terms of conditions on bond or the term of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. So your bond conditions: not to use any illegal controlled substances, not to use alcohol. You must enter and complete the program you're in right now. You're not to leave without permission, and you're not to commit any new crimes. If you were to violate any of those, then do you understand that I could give you the maximum amount of time in jail, and or you wouldn't qualify for HIDA? Do you understand that? Or I'm sorry, not HIDA, 7411.
Yes, Your Honor.
Okay, and do you understand all of that?
Yes, I do.
All right, if you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, Ms. Smith?
No, Your Honor. I just want you guys to know that I am in Bear River, so I won't be able to report to probation until I complete the program.
Yep, we're aware of that, not a problem. So how do you plead to the charge that on or about July 23rd of 2025 in the city of Adrian in the county of Lenawee that you did commit the offense on an added count to attempted controlled substance use of cocaine? Guilty or not guilty?
Guilty, Your Honor.
All right. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
And do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea to induce the defendant to plead guilty? Mr. Malaro,
No, Your Honor.
Mr. Sneed?
No, Your Honor.
All right, is it your own choice to plead guilty, Ms. Smith?
Yes.
All right, so Ms. Smith, on July 23rd of 2025, we're in the city of Adrian in the county of Lenawee. Say that again.
Yes.
Okay, and did you, on that date and time, use cocaine?
Yes, Your Honor.
Did you have any legal right to use cocaine?
No, Your Honor.
All right, Mr. Sneed, are you satisfied?
I am, thank you.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Malaro?
I believe the court has, yes.
Mr. Sneed?
Yes, Your Honor.
Hold on one second. All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them, unless they're outside of the agreement for 7411 if she's eligible. I am going to refer this matter to the district court probation department for a pre-sentence investigation. So this is a one-year misdemeanor. So the district court probation department will be doing the pre-sentence report. So Ms. Smith, Mr. Malaro, do you have contact information from Ms. Smith?
We do, Your Honor, yes.
Would you be able to send that to district court probation, Mike McCarron?
I would be willing to do that, Judge.
All right, and Ms. Smith, you may have to sign a waiver so that Mr. McCarron or whoever is assigned as your probation officer can communicate with you. And I'm gonna give you a number. Can you write it down?
Yes, just give me 1 second.
Sure.
Okay, go ahead.
All right, so it's gonna be area code 517-264-4683. It's district court probation. You can call and just tell them your name. They won't have your file yet, but call next Monday or Tuesday, give them your name, and they'll put you through to talk to somebody to make arrangements. Mr. Malaro, are you available for sentencing on December 5 at
Yes,
8:30 or 8:15?
Yes, Your
So I'm
Honor.
gonna set this for sentencing on December 5 at 8:15 in the morning. So Ms. Smith, when you meet with the probation department, be truthful with them about your background, the events that occurred, what you're doing now, and they'll prepare a pre-sentence report. Mr. Malaro will share a copy of that with you and review that with you before the day of sentencing. And we will see you back on December 5 at 8:15. Do you wish to appear in person or via Zoom?
I can appear in person.
Okay, how long are you gonna be there?
My out date for here is the 27th.
Okay, all right, good. All right, we'll see you back on December 5 at 8:15 in the morning. Okay?
Thank you so much.
Good luck.
Thank you. You have a good day.
You too, thank you. Mr. Malaro, in the matter of the people of the state of Michigan versus Cade Robert Packard, file number 25-22394FH. This is the date and time set for a pretrial conference in this matter. Mr. Packard has not appeared via Zoom, and he is not present in the courtroom. Have you been able to locate him? He's doing well. So Darren Coase provided a letter that stated that he's testing twice a week. He does test positive for marijuana without a medical marijuana card. Said his last use was September 21. He gave him 30 days to get it out. He did his TCN. So Mr. Coase he's been maintaining contact, right?
Yeah, Judge, I'm surprised he's not here this morning. And I don't know if I have a phone number for him. I mean, I'll check into that and try to get a hold of him if I do.
All right, I'm gonna adjourn this because
Okay.
he is compliant with his bond conditions, so I think it's probably a mistake, Mr. Malaro, and I'm looking, we did,
Whoa, what the heck is that?
give him a notice of hearing. It was mailed out for today, but I'm gonna adjourn it, Mr. Malaro, to October 22nd.
Okay. Yeah, Judge, I'd be willing to call him if the court wants to wait a minute.
Oh, we're moving along. So October 22nd at 8:30 in the morning, you can do the stip and order. Mr. Sneed, can he sign your name with permission?
Yes, thanks.
All right, and then just make sure you get a copy to him. All right?
Yep. All right, Judge, thanks. We'll do that.
Okay, no problem. Another one? Okay. Not amended plea agreement? Okay. All right, so Mr. Fry, Mr. Sneed, I received another amended plea agreement on Lewis Adams. So Mr. Fry,
Yes, I believe it has been corrected, Your Honor, and my understanding is my client would be proceeding with this plea. So we just got this kind of worked it out yesterday. So I was in there yesterday morning, but I haven't been back since we got the written one. So I haven't gotten him to sign it or the advice of rights yet, but he's in jail. So hopefully that could be taken care of.
okay, we will send the advice of rights over. Mr. Fry, was Miss Arnold zooming in?
She said she was in Judge Olsaver's court. She said she'd be finished soon, so I'm not quite sure if she wanted us to wait for her or not.
Mr. Steen?
Judge, I sent her a text letting her know the court's ready, but I haven't heard back at this point.
Okay.
But she did want to be present, is my understanding.
So we'll give her just a moment.
Thanks, Judge.
No problem. Still gonna have to come see me, you know. I've gotten used to you being here.
I will periodically come and just listen, I like to listen.
I'm told she'll be here in a minute, Judge.
Okay, you're good. Miss Adams, can you let the jail know he'll need two advice rights, one for file number ending in 11 and one and file number ending in 12. Did you get a copy of the amended plea agreements, Ms. Spade?
I have it on, yes, they emailed it to me. Thank you so much.
Oh, and we have Miss Arnold. All right, so this is in the matter of the people of the state of Michigan. Hold on, let me put this other file. It's popping away. Louis Alfred Adams Jr. We have file number 24-21947FH, 24-21948FH, 24-21949FH, 24-22011FH, 24-22012FH, and 25-22337FH. I have Allison Arnold appearing on behalf of the people, and I have Brian Fry appearing on behalf of Mr. Adams. Mr. Adams is joining us from the Lenawee County Jail. I have received this morning multiple, but the final amended plea agreement, which states that Mr. Adams will be pleading guilty on file number 24-22011FH2. Let me get there. Which is larceny in a building, which carries a maximum penalty of up to 4 years in prison. And then on file number 24-22012FH, he'll be pleading guilty to count 2, larceny from a person, which carries a maximum penalty of up to 10 years in prison. Count 3, police officer R&O, assaulting, resisting, and obstructing, which carries a maximum penalty of up to 2 years in prison. And count 7, home invasion 2nd degree, which carries a maximum penalty of up to 15 years in prison. Both parties agree the defendant shall be sentenced to a prison term with a minimum term set at 5 years in prison, and that all remaining charges and habitual offender supplements in all listed files will be dismissed. So all of the other files will be dismissed at the time of sentencing, along with all the other counts and the habitual offender notice. And the sentence for all charges shall run concurrent to each other, so they will not be stacked. So even though the box is marked that entering this plea allows this court the discretion of imposing consecutive sentences, on the second page, the sentence for all charges will run concurrent as part of the Killebrew. So is that a correct recitation of the plea, Ms. Arnold?
It is. The only other condition is that restitution on all the listed files, whether pleaded to or dismissed, as determined by the court, will be paid by the defendant.
All right, Mr. Fry, is that a correct recitation of the plea?
Yes, Your Honor.
All right, so.
How much is the restitution?
I don't know the figure.
So what happens, Mr. Adams, is once you enter the plea, we'll order a pre-sentence report. Victim impact statements will go out to any victims in this case, and they will have an opportunity to provide that information for restitution. And then if you disagree with that, or you believe that amount is not correct, then you can have a hearing on it, okay?
Okay.
All right, Mr. Fry, correct recitation?
Yes, Your Honor.
All right, so Mr. Adams, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, can you state your full name for the record for me?
Louis Alfred Adams Jr.
Okay, so Mr. Adams, you've heard the statement of your attorney, the prosecuting attorney. Is it your intention then on file number 24-22011FH to plead guilty to count 1, larceny in a building, which carries a maximum penalty of up to 4 years in prison, and then on file number 24-22012FH to plead guilty to count 2, larceny from a person, which carries a maximum penalty of up to 10 years in prison, count 3, police officer assaulting, resisting, and obstructing, which carries a maximum penalty of up to 2 years in prison, and count 7, home invasion 2nd degree, which carries a maximum penalty of up to 15 years in prison. So is it your intention to plead guilty to those counts?
Yes, ma'am.
All right, are you satisfied with Mr. Fry as your attorney and the advice that he has given you?
Yes, ma'am.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty. You do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea? Hold on. I'm so sorry. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. So basically, in your case, because you're currently incarcerated, if you were to commit a new offense while incarcerated, like assault of an employee of the prison or the jail, you could, this plea offer could be taken, the plea offer would continue, but I could do whatever I wanted at sentencing. Do you understand that?
Yes.
Okay. If you're not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that are given to you?
No, ma'am. Just about the restitution. That's all I have a question about.
But did I already answer your question regarding restitution?
Yes.
Okay, good. All right, so how do you wish to plead to the charge? And this is on file number 24-22011FH. How do you wish to plead to the charge that on or about August 9 of 2024 in the city of Adrian in the county of Lenawee that you did commit the offense of larceny in a building? Guilty or not guilty?
Guilty.
Okay, and we're going to move on to file number 24-22012FH. And on this file, Mr. Adams, how do you wish to plead to the charge that on or about September 6th of 2024 in the city of Adrian in the county of Lenawee that you did commit the offense listed under count 2 of larceny from the person? Guilty or not guilty?
Guilty.
And count 3, police officer assaulting, resisting, and obstructing. Guilty or not guilty?
Guilty.
All right. Hold on one second. Could you talk to Lisa? She doesn't typically call me, so I'm worried. And how do you wish to plead to count 7, home invasion, 3rd degree? Guilty or not guilty?
Guilty.
All right. So if you just tell her I'll call her back, or if there's an emergency.
Yeah, she's talking.
It's an emergency. All right, I'm gonna step off the bench for 1 second because I have an officer calling me for a situation, so I'll be right back.
Please rise for court's now session.
Sorry about that. All right, I'm sorry, Mr. Adams. Okay, so, Mr. Adams, and we will get you a copy of the, advice rights form to go through. So, has anyone made any threats or promises to you to induce you to plead guilty to these charges?
No, ma'am.
All right, do you understand if I accept these pleas, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the pleas? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargains to induce the defendant to plead guilty? Ms. Arnold?
No, Your Honor.
Mr. Fry?
No, Your Honor.
So, Mr. Adams, other than the Killebrew agreement that was placed on the record, has your attorney promised you any other particular sentence or estimated what your sentence will be other than the agreement?
No.
All right, and it's your own choice to plead guilty on these files?
Yes.
All right, so, Mr. Adams, we're going to start with file number 24-22011FH. So, Mr. Adams, on or about August 9 of 2024, were you in the city of Adrian in the county of Lenawee? This is the larceny in the building for stealing a cell phone and a smartwatch. So were you in the city of Adrian on that day?
Yes.
All right, and would you agree that was in the county of Lenawee?
Yes.
All right, so at some point you went into a commercial building and you took a cell phone and a smartwatch. Where did you go to, what store were you in?
I don't know the name of it. It's just I think it's a boat repair company.
Okay, Ms. Arnold, do you have the name of the business or boat repair business?
Yeah, it wasn't a store per se. Let me see if I can.
It was a business?
Yeah, yes.
Some kind of warehouse.
Right,
Okay.
correct.
All right, and did you work there? Did you know anybody
No.
there or no?
No, I was collecting cans and I found it right there and I got it.
Okay, so you were collecting cans and you saw somebody's phone and a smartwatch, so you took it?
Yeah.
And did you have permission to take that?
No.
Okay, all right, and when you took it, was it your intention to deprive the owner of it?
Yeah. Yes.
All right, Ms. Arnold, are you satisfied?
I am.
So let's move on to file number 24-22012FH. So this one, Mr. Adams, is also in the city of Adrian. So on September 6th of 2024, we're in the city of Adrian in the county of Lenawee.
Yes.
Okay, so on that day, did you take a brown purse from a woman named Barbara Gilbert?
Took money from a purse.
Okay,
Yes.
so her purse, where was her purse?
In the shopping cart.
Okay, so it was in the shopping cart, and what were you in a store?
Yes.
Okay, and so you grabbed her purse and you took money out of it?
Yes.
Okay, and did she give you permission to do that?
No, ma'am.
And when you took that money out of it, was it your intention then to deprive her of the value of that money?
Yes.
All right, are you satisfied on that count, Ms. Arnold?
I am, thank you.
All right, and now at some point you came in contact with the Sergeant Snowberger with the Adrian Police Department, is that correct?
Yes.
And was it daylight out or was it nighttime?
It was daylight.
All right, and did you have permission, or I'm sorry, and he was wearing a uniform, correct?
Yeah.
It's a, yeah,
It's a she?
Yeah.
Okay, I'm sorry, I don't know
There were
her.
multiple officers though, yep.
Okay, so she was wearing a uniform and you knew she was an Adrian police officer. Mr.
Yes.
Adams?
Yes.
Okay, and did she tell you to stop? Did she tell you to put her hands behind your back? What did she ask you to do?
Your Honor, I can't remember, to tell you the truth.
Okay, did you try to get away from the police?
I'm pretty sure, yes. I barely
Okay.
remember 'cause I was on Spice on K2 and
Okay, but
All right.
they were trying to arrest you and you didn't want to be arrested, so you obstructed them in some way.
yes.
All right, Ms. Arnold, perhaps you can give us some details?
He ran from Meyer and the police were chasing him and Mr. Adams continued running and then he ran into a residence without permission. That's the gist of the rest of the offense.
Okay, all right. And then, all right, so when you ran from the cops, then you went into a house at 404 April Lane here in Adrian?
Yeah, I didn't go in. I just opened the door and was about to go in, but the
right,
police
so you-
told me.
So you put your hand on the door handle and you open the door?
Yes.
Okay. Are you satisfied, Ms. Arnold?
Judge, I believe some part of Mr. Adams' body passed the threshold of the door, if we can cover that.
All right,
And
so
I think
Mr. Adams, when you open the door, you push the door in?
Yes.
Would you agree your hand went inside that house?
Yes.
Okay, and then the next one, Ms. Arnold?
That's it, basically. He went in, and that was while the police were still looking for him.
Okay, would you agree with that, Mr. Adams?
I don't know how to answer this question.
Well, you ran in there to get away from the cops, right?
I didn't run into nobody's house, so.
But you opened the door and your hand went in the house, didn't it?
Yeah, because I was trying to knock on the door while it was being open. Yes.
Yeah, okay. Ms. Arnold?
I think if Mr. Fry and I can stipulate that's while the police were still attempting to apprehend Mr. Adams, then I think that's fine.
Yeah.
And you would agree with that, Mr. Adams? The police were still trying to get you and you were trying to get away from them?
Yes.
Okay.
I'm satisfied.
Okay, so that would be for count 3 and count 7. Has the court complied with MCR 6.302 B, C, and D? Ms. Arnold?
Yes, Your Honor.
Mr. Fry?
Yes, Your Honor.
All right, I accept the plea. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I'm going to refer this matter to the probation department for a pre-sentence investigation. I'm going to set this matter for sentencing on December 5 at 8:15 in the morning. Mr. Fry, are you available December 5 at 8:30 in the morning?
Yes, Your Honor.
Are you available, Ms. Arnold?
I am.
All right, so Mr. Adams, December 5 at 8:30 in the morning. You can appear via Zoom or in person. What would you prefer?
In person.
Your mom's usually here.
Yeah.
In person?
Yeah, that'd be good.
Okay, now, Mr. Adams, someone from the probation department is going to meet with you to do a pre-sentence report. When you meet with them, be truthful with them about your background and the events that occurred as much as you can remember. They'll prepare a pre-sentence report. Mr. Fry will get a copy of that, send you a copy and review that with you before the day of sentencing, and we'll see you back on December 5 at 8:30 in the morning. And I wish you anything else, Ms. Arnold or Mr. Fry?
I think that's it, Your Honor.
Nothing further, Your Honor. Thank you.
All right, we'll see you back on December 5 at 8:30 in the morning in person. Thank you.
Thanks,
Thank
Judge.
Thank you.
Hi, this is Judge Anzalone. I am ready on Cody Lowe.
Cody Lowe, you got it.
All right, thank you. Bye. Have a good day. So Mr. Degermark goes in. Mr. Sneed, we have a PPO pretrial. Are you here on that one today? For the show cause? Okay, so this is in the matter of Cynthia Hoyle versus James Hall, file number 25-52721PH. So Mr. Degermark goes in again. I appreciate very much you appearing on behalf of Ms. Underwood. I realize that also does put you at some disadvantage. So how would you like to proceed today?
Well, Judge, I reviewed the information. I spoke with Mr. Hall, and based on my understanding of the violation and the facts, I think it would be appropriate to set this show cause hearing.
Okay. All right, and I think I have someone on a Motorola device. Could you possibly unmute your device for me, please?
Mine?
No, you're all right. All right, so ma'am, go ahead and unmute your device. I think it might be Miss Hoyle. All right, is that Miss Hoyle, sir? Right, ma'am, on the bottom left of your screen, there should be like an audio, microphone, something. It's got a red line on it. You just need to tap it and it should unmute it. All right. Nope, she just disconnected. Well, I think that might be her, but I'm not sure. So Miss Adams, I'm looking for an evidentiary hearing of 1 hour.
Okay. Judge, we could do October 23rd at 1:30.
Is Miss Underwood available that day?
Yes. Yeah, she's good.
Mr. Sneed, October 23rd at 1:30.
That works for the people, Judge.
All right, Miss Hoyle, is that you?
Yes. Yeah, that's
okay.
me.
Okay, good. All right, so we're going to set this for an evidentiary hearing on the show cause, October 23rd at 1:30 p.m. That will be in person. So October 23rd at 1:30 p.m. And Miss Adams, we mailed the notice out of that, right? So we'll send one to Miss Hoyle, but could I get a copy from Mr. Hall?
Your Honor, if I may just, Mr. Hall indicates to me that he is going to be going to Bear River Rehab pretty soon for what he believes to be 90 days. So I don't know. I mean, if he could appear by Zoom, he could do that, but.
So Mr. Sneed, I don't know if you caught that, but Mr. Hall is going to be heading off to Bear River for a 90-day program. Is there any objection to setting this out a little bit?
I would defer to Ms. Hoyle. I don't see any reason to object if he's not going to be, local violating the PPO. So if the court could inquire with Ms. Hoyle, I'd appreciate it.
So Ms. Hoyle,
yes.
Have there been any more recent violations?
No, since he's been gone out of here, it's been a piece of quiet.
All right, so Ms. Hoyle, Mr. Hall is going to be at a program. Do you have any objection to me adjourning this out? This does expire in January, so I would like to do it before the expiration date. But Miss Adam, okay, so Miss Adams, this PPO is set to expire on January 10. Is it possible to get a hearing date week or for that?
Could do a week before January 10th. Is that what you said?
Yes, ma'am.
We could do December 30th at 11 a.m.
December 30th at 11 a.m. December 30th at 11 a.m. is a Tuesday. All right, so can I get a notice for that, please? All right, so Mr. Paul, we're gonna get you a notice of hearing. So if you're still in the program, you're gonna have to zoom in, okay? All right, and Ms. Hoyle, do you want to zoom in as well?
Yeah, that's fine.
Okay, so I will set this via Zoom, December 30th at 11 a.m. and we'll mail you a notice of hearing, ma'am, okay?
Okay, thank you very much.
All right, thank you. And you just stay right there and we'll get you a notice, okay?
Okay.
All right, thank you, Mr. Degamargosian.
Mr. Hall said he has a
I have a question. I had a friend of mine, her brother stays at.
Sir, you've got to speak up. So, Mr. Degamargosian, I would ask that you first speak with him out in the hallway and then come back in and relay what the question is. I don't want him to say something shit.
Yes, it is. Yes.
All right, so Ms. Hoyle, I'm going to go ahead and disconnect you. You have a good day.
Yeah, you too. Thank you very much.
Thank you. All
Welcome.
right, Mr. Noe. Charles Noe. Oh.
Good morning.
All right, so this is in the matter of the people of the state of Michigan. No, you got to get your notice.
I got it.
Did she give him one? Okay, all right, thank you. All right, so this is in the matter of the people of the state of Michigan versus Cody Joseph Lowe. We have two files, 21-20527 FC and 23-21347 FC. I have, this is the date and time set for probation violation pretrial. I have Isaac Sneed appearing on behalf of the people. I have Charles Noe appearing on behalf of Mr. Lowe, and I have Sarah Teskey from the Michigan Department of Corrections. I'm trying to update people as we go. Mr. Noe, I don't know if it's relevant to this case or not, but the RAP program out of Genesee County, which was an amazing program that we were using for probation violations, has closed due to budget cuts. I'm deeply saddened by that, but going forward for any of your clients, I just wanted to make you aware of that. So, Mr. Noe, how would you like to proceed today?
Judge, I was wondering if we can have a brief bench conference on this matter.